Good morning and welcome to today's Ask a Pro webinar. Today's topic is the bookends of bankruptcy. My name is Milos and I'll be the moderator for today's session. A little bit about myself. I am a shareholder here with the firm. I have been with Weltman, Weinberg & Reese for 9 years and I have been practicing law. This November will be 20 years, believe it or not. I don't believe it myself sometimes. I have been doing bankruptcy work for my entire 20 years. I first started with a creditors' rights firm for about 2 years. Then I did debtors bankruptcy, where I represent individual debtors and businesses that were filing for bankruptcy. I did that for about another 10 years. And then after that, I joined Weltman and went back on the creditor side. Now, let's learn a little bit more about our other panelist, Garry Masterson.
Good morning, everybody. My name is Gary. I'm an attorney here at Weltman. I've been with Weltman for a little over 7 years. Before I was practicing bankruptcy about 4.5 years ago with Weltman. I was in a management role here. Currently, I am licensed in multiple jurisdictions across the country, so I am able to provide a diverse knowledge base of different experiences you may see from district to district, trustee to trustee.
Great, thank you, Gary. Before we get started, I just want to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is also being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Also, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. Couple items too. You guys did send in some questions ahead of time. We will try to get to those, but we are prioritizing questions that are going to be on topic. We typically have some time at the end of these webinars to go over some questions that may be a little bit off topic. But we are going to prioritize things that are going to fall in line with what we're kind of going over today. And another announcement, which you may or may not be aware, which you should be aware because you sent out mailers, we are actually moving our Cleveland office. Starting the end of this week through next week, we'll be completing our move. For those of you that have been to our current office, we're moving less than a mile away. Our new address is going to be 5990 West Creek Road, Suite 200, Independence, Ohio, 44131. For those of you familiar with the area, we are going to be in the building behind the Cleveland Clinic building on 77 and Rockside and Independence. So I think it's less than a mile from where we're at now. All right, without further ado, let's get started with the current program. So today we're talking about the bookends of bankruptcy. So we're specifically going to focus on, as soon as you get the bankruptcy notice, what happens, what do you need to do, and then when the bankruptcy case is about to wrap up, same thing. What are our responsibilities? What are we doing on the back end here? To kind of give you an idea of the beginning end of the cases. So the first question that we want to address is, how does the automatic stay work and what do we do? So basically what the automatic stay is, the bankruptcy code has a code section that protects the debtor when they file for bankruptcy. So what that means is, as soon as that bankruptcy is filed, that individual debtor is protected from his creditors. What does that mean for you? You cannot make any phone calls or collection calls to the debtor. You can't send any billing statements. Essentially, you can't make any efforts to try to collect a debt. You can't look to repossess a vehicle. You can't take any of those measures once an individual files for bankruptcy. The reason they call the stay automatic is because the stay goes into effect as soon as the bankruptcy case is filed. So there's no requirement that you have actual notice, and there's no burden on the debtor to notify you in the sense for the stay to be effective. That gets a little tricky because sometimes when a member or a debtor files for bankruptcy, you may not get the actual notice for like a day or two after the case is filed. Then the question comes up, well, we were collecting on the debt, or we repossessed the car, or we we did this or that. We had no idea the bankruptcy case was filed. Are we going to get in trouble? Generally, no. I've never seen a situation in 20 years where the court has penalized the creditor for accidentally collecting on a debt between the time a debtor files a bankruptcy and they receive actual notice. It's generally a no harm, no foul kind of approach. And I think even most debtors' attorneys are pretty reasonable in the sense like, all right, we get it. We filed today at 5 p.m. and you did something at 5:01. We're not going to chastise you for it or take you before the judge. So, there is some sensibility in terms of that. But the stay is automatic. You can't just say, we never got the notice, so we're just going to keep doing what we're doing. It doesn't work that way. If you found out in some capacity, verbal, you did a bankruptcy scrub, debtor's attorney or debtor told you something like that, you can't just disregard it. There's no like formal way you would get notified. Couple of things just to remember with the automatic stay. Obviously the most basic stuff is the collection calls and sending out like the billing statements. But a couple of things that kind of, I guess we'll call them hot button items or things that people may not be aware of that a lot of my clients potentially get in trouble on is automatic payments, right? I get that question a lot. You have a debtor, he set up an auto pay for an account, whether it's a credit card, car, house, doesn't matter. He may have voluntarily set it up, signed all the paperwork, but once the bankruptcy is filed and that automatic stay goes in effect, that agreement that you had prior to the bankruptcy does not supersede the automatic stay. Now, it's not to say that the debtor can't set that up again or call you and say, hey, I filed the bankruptcy, but I still want these auto payments going. I think there has to be an affirmative act after the bankruptcy case is filed to kind of reinstate that process. Unless you have some sort of confirmation, and I would always recommend putting it in writing again, I wouldn't start up any type of automatic payments with the debtor after a bankruptcy is filed unless you confirm that with the debtor. Obviously it seems like a little bit more of a no-brainer when it's a car and a house and they want to keep it, but where it gets a little tricky is if they have an unsecured account and if they verbally told you like, hey, I'm going to file bankruptcy, but I still want to pay on my credit card. If after the fact, if they change their mind and you're relying on something they said prior, I've seen it many times before where the debtor's attorney will come in and say, hey, you're taking payments out, my debtor, filed for bankruptcy, we want that money back. And my client will come and say, well, they told us verbally before the bankruptcy was filed, they didn't want to interrupt these payments. I said, you know what, unless you had something in writing after the fact, I don't think any court's going to rule in your favor to let you keep those funds if the debtor's attorney makes a just think about it. So just make sure you follow the rules and even if the debtor voluntarily wants to make those payments, make sure you get some sort of confirmation in writing before you start those up. Repossessions. We could spend a whole day on those repossessions and how they kind of come into play with the bankruptcy. But generally speaking, if the debtor files for bankruptcy and you repossess the vehicle after the bankruptcy is filed, you always have to give that if the debtor asks for it back. There may be situations where they say, listen, I don't want it, you can hold on to it, that's fine. But if the debtor files for bankruptcy, you repossess it after the fact and you find out later he filed for bankruptcy and they want it back, you're going to have to give it back. There's no way around that. A couple other items that have come up recently that people don't think of: locking somebody out of their bank account. Okay, so let's say somebody has a loan with you, they file for bankruptcy, they don't make their payments, you say, you know what, we're not going to give them access to their checking and savings. I think that is a stay violation. I understand with some of our credit union clients, they have an agreement that if the debtor causes them a loss, they can no longer be members of the credit union. That's fine. That's something to be addressed after the case is completed. But as soon as the case is filed, to prohibit or restrict someone's access to their own funds, that's going to be a huge problem. You cannot do that. They still need to have access to their normal banking statements. Now, just to make sure there's a distinction, because sometimes we get some of that confusion too. We're not saying they should access their credit line or their credit card. Those should be stopped as soon as somebody files for bankruptcy, because You don't want them to incur debt after the bankruptcy is filed, because then it kind of gets into a gray area whether they owe it or not. But we're talking about their actual money that's on deposit. So don't stop any direct deposits. Don't, cancel their online access to manage their account. They should have access to their bank accounts. The other thing that's come up recently is not just with the initial bankruptcy, is court reporting, right? Credit reporting. Our member filed for bankruptcy. How do we, report this to our credit? Now, I can't, I'm not familiar with the credit reporting system or what the codes are or whatever, but the reality of the situation, if somebody's filed for bankruptcy and they're in an active bankruptcy, that probably should not be listed as an active account. So I don't think that they should get dinged for any kind of late payments or deficiencies in there if they're in a bankruptcy. My understanding, from interacting with clients, is that there is a way that you can put it in a active bankrupt code when somebody files for bankruptcy. And obviously Gary will touch on the back end once the bankruptcy is done. But while the bankruptcy is pending, I think, people are very savvy nowadays with their credit and credit scoring. And, if they file bankruptcy and they're taking credit hits, and they make that an issue out of that, I think that could potentially be a problem. All right, I'm just gonna take a quick pause because I just saw in the corner of my eye, we got a lot of questions, and I wanna make sure that address these if they're on point here. So we got quite a few here. Let me scroll up. Okay, I'm gonna grab the ones that are on point. All right, what happens if the debtor does not include the creditor in their petition and we find out that find out about the case via scrub? Same thing. If you find out about it late after the fact, you're still bound by that automatic stay. We can go down a rabbit hole here with that, because if the fact that you weren't listed caused other problems, like you ended up missing out on money or you ended up filing a late claim, there's ways that we can get that allowed or the discharge potentially denied depending on the circumstances. So if it's a situation where you caught it via scrub and it didn't harm you in any way, right? Like you still were able to file a claim on time, get a reaffirmation agreement filed, object to a plan, then it's kind of, once again, no harm, no foul. Now, if you weren't listed and you find out via scrub and it cost you something, right? The plan got confirmed and you had no idea, right? I think we could potentially, raise that issue and unwind those things based on the fact that you did not have actual notice of the bankruptcy. So I guess it just depends on whether you were harmed or not. Motion for relief. All right, there's a motion for relief question. It's kind of on point, but let me go through the other ones first, and we may circle back on that one. All right, this is a good question, actually. I didn't want to bring this up. What if the debtor says they're filing for bankruptcy, but the attorney won't verify? How long do you wait to start back up collection efforts? This has been my consistent thought on all of this. If the debtor says they're filing for bankruptcy, but their attorney, I don't understand why their attorney wouldn't confirm. The only reason I could think that they wouldn't confirm is that they actually retained the attorney but didn't file. So my position has always been, unless or until you actually verify that they filed for bankruptcy, don't take their word for it. Keep moving forward to collection, because the problem you're going to have is if the debtor calls you and says, hey, I just consulted with the attorney, I'm filing bankruptcy tomorrow. And you say, all right, this guy's going to file bankruptcy tomorrow. We're going to stop everything. And they drag their feet and they don't file it for 6 months. What did you gain? That harms you. Now look at it on the flip side. If they say they're filing for bankruptcy and you say, all right, let me know when you file, we're going to keep pushing forward. What's the worst that can happen? You have a little bit of, you exert some effort, and you collect on the debt, and then you have to abruptly stop, or you maybe have to unwind something. But to me, that's not a big ask, right? But on the other side of things is, if you keep moving forward and you start garnishing his paycheck, you repossess the car, sell it, you may be able to accomplish all of that before he even files for bankruptcy. Because not to say that I don't believe that the people are not going to file for bankruptcy, but there's a lot of moving parts and pieces, and a lot of times they don't move as swiftly as they claim they're going to move. So that's my position on it. So I was going to ask Gary how he felt about it. I saw him nodding his head. So
I'll I'll jump in really quick on that. Yeah, so I completely agree with you. It can be used as a stall tactic at times. And another situation that's similar but slightly different is you may have a debtor who filed bankruptcy, and at some point they get dismissed. And I've had more times than I can count that either debtors have called us or their attorneys from the first case have called and said, you know, they're going to be filing a new bankruptcy. Well, that's great, but usually you're gonna have your account's gonna come out of that first bankruptcy behind if it wasn't already behind. And so if you have a car, my recommendation normally is if that is falling within your normal repossession parameters, proceed as you normally would if the bankruptcy hasn't been filed, because a lot of times they'll drag their feet and they know that they're coming out of that bankruptcy behind. And so they want to try to get out ahead of you and try to preempt you collecting and taking efforts to secure collateral. So, worst case scenario that happens there is you repossess the car while you validly can in between the bankruptcies, and then you have somebody asking for the car back. In that situation, which we can talk about, because I think there might be another question later if we get to it, you're in the same position as if you repossess that car pre-petition on another bankruptcy. It's not any different because one case was dismissed. They're telling you they're going to file. You get the car, and then they file again. So you might be in my opinion, you'd be in a better position to possibly leverage that, either to sell the vehicle by getting relief or, negotiating in another way. So definitely, I would agree. Just because they're telling you that you're under no obligation to take action until you have notice.
I will say this, while Gary was kind of giving his input on that question, I was going through the questions, and I think we kind of hit a nerve on something, not in a negative way, but we had a lot of the same questions in terms of the restricting the access to the account. So I see that there's a lot of questions related to that. One of them was, I'll go through them one at a time. I think the answer is going to be the same on all. Are we allowed to stop the online banking and debit cards and make the member come into the credit union to withdraw funds? My answer to that would be no. I kind of feel like you're, in this day and age, how many people come into a physical branch? I think you're really restricting them financially by doing that, to the point where, can the court say you're violating the stay? I would say, yeah, I really think that they need to have full, uninterrupted access to their personal money, checking and savings. That's my position. Now, I know some of you may not have done that. You've never had any issues. That may be the case, but if you want to maintain that practice, it's up to you. But I think you're potentially putting yourself at risk for a stay violation if that became a problem. If you have a member file for bankruptcy and they go to the store and they have $1,000 in their account and they go to buy food for their kids and they use their debit card and their debit card's locked out, and their attorney says, you locked my client's account out, that's his money, he should have access to that money. And he takes it before the judge, and that fact pattern is probably not favorable to you if you're going to make an argument that wouldn't violate the state. We just, it's our policy, just kind of lock access to their debit accounts. I just don't think that's sufficient enough. Gary, you're going to say something. I don't want to
just give just one brief after that. And I along with what Milos is saying, think about it like this. If you have a debtor who is trying to make a Chapter 13 plan work, and they're trying to fund that plan, that requires normally them getting to work. And so if they're using that debit card to put gas in their car or anything else in order to get to work to make money to fund the plan, they're going to run in front of the court, and they're going to make a pretty good argument that you're infringing on their ability to comply with the terms of their plan and fund their plan and pay creditors. So you don't want to be put in that position. You're going to spend money defending that and getting nothing out of that.
Yeah, Gary, that's actually a great example. It's better than the example I gave. Here's another kind of similar question, but I like the specificity of it. Once a loan goes 30 days past due, we block debit cards. If they're in bankruptcy process, do we need to figure out how to allow them to keep access to debit cards or their checking debit cards for their checking accounts? I don't know what you mean by the bankruptcy process. I'm assuming they've already filed. If that's what you meant, then the 30 days past due, I think that doesn't matter. The automatic stays in place, whether they're behind 30 days or 300 days. It's behind, the automatic stay still applies. So I think once somebody files for bankruptcy, those automatic triggers that you have that say the debtor's delinquent 30 days, we shut his account down, those shouldn't apply. I think the automatic stay protects them from that. Here's a good one, hypothetical. It's kind of odd. If a member creates an auto pay after they filed and you have not received notice, do we keep or disable? Boy, that's really kind of fact specific. I don't know. I don't want to dwell on it too long, but it's probably a unique situation. I would maybe initially say keep. I'd have to look at the circumstance. If the debtor knew that he filed bankruptcy and he specifically went in there to do that because he knew he filed, he wants to make sure it goes interrupted, then I would say, yeah. But he doesn't have to necessarily tell you that, but how do you know that? That would be a bizarre situation. Why would he not have the auto pay before the bankruptcy? So I don't want to dwell on it too much, but I think you'd be okay. But
I'll just throw a 2-second in there. So I agree. I think you would normally be okay, and I think you would have a defense if they tried to claim it was a stay violation. That yes, it's a technical stay violation. However, it wasn't willful on your end. You didn't set up the auto pay yourself. You didn't have notice. The debtor did it themselves. The only thing I would caution is you can sometimes have a rogue court, rogue judge or debtor's attorney. I've had an instance once or twice where they make a claim because they know they have a sympathetic judge, and even though it wasn't willful, debtor set it up after they got settlement money to make them go away. But I agree. Generally, you're not doing anything willfully to violate the stay.
yeah. I don't want to dwell on this because I want to go on my next topic for at least a couple minutes, but there's a really, really good question here. So Gary, all right. So I'll summarize the question. So the issue was, I stated earlier that you cannot send billing statements. You can't restrict online access to checking or savings accounts. So the question in essence asks, what if it's the online account or the online statement show like a credit card or a loan? So if you get a statement from the bank and it says, all right, here's your checking, here's your savings, here's your credit card bill. So everything's on one statement. So the statement that you're sending for the checking and savings is also the statement that's for the debt. So the question then is, what do we do in those situations? If you can, you want to remove the debt from the statements, right? Eventually, if they get their discharge, it should show zero. But if you can remove it altogether or remove it on the online account so it's not showing as active, that would be the ideal scenario. Now, if you can't, and the debtor wants statements and wants to online access, I'm kind of torn on it both ways. But I think if it's a statement that has everything on it, I think you're okay with sending it, because I think the debtor's access to his checking account is a greater benefit to him than the detriment of him actually looking at a potential statement that he doesn't owe. I don't know if that makes sense. Gary, what are your kind of thoughts on that? If you had to pick one or the other, if you had no choice.
I think you're okay. I mean, out of an abundance of caution, if they want statements, I would, if you can get something, the same as auto pays, if you can get something in writing from their attorney that says, because normally they'll put in a letter, we're not going to consider it a stay violation to send statements, as long as they know that everything is going to be on their statements, which they should, because that's what they received before. Get it in writing, and then you're protected. And I think you're fine then, because they're going to have access to see what they need to see for their banking accounts.
Okay. All right, let me hit my next subject real quick because it'd be fairly simple. The second question, I want to get in a couple minutes to give Gary enough time for his subject. When do you need to file a claim? Yeah, that's pretty simple. In a Chapter 13, always. So if the plan provides for payments to you as a creditor, don't assume that you don't have to file a claim because the plan provides it. is not the case. They will not pay the claim, regardless of whether it's in the plan or not, without a proof of claim. So you always have to file a proof of claim. The trustee will not make distributions without it. Now, situations where the plan provides for direct payment and you're not getting money from the trustee, should you file a claim? I always think it's a good idea, just for transparency purposes. So there's no questions later, what was owed, how much was owed, whatever. And there's always a chance that the plan can be amended down the road, or the debtor falls behind on payments and then you have to change your claim from secured to unsecured, or they decide they want to pay it through the plan. I just think as a matter of practice, it's always a good idea to file a claim in a Chapter 13, even if you're not going to get paid by the trustee. In a Chapter 7, you only file a claim if you get notice of assets, and generally you only file a claim if you're an unsecured creditor. If you're a secured creditor, the anticipation is you're going to get paid by the debtor through either voluntary payments or reaffirmation agreement, and if they don't, you have the right to repossess the collateral. You may want to consider filing a claim for secured debt if the debtor is not paying on it, or you plan on repossessing it and you think that after sale you're not going to get enough to cover what's owed and there may be a deficiency, then you would consider filing that in a Chapter 7. So sorry to brush through that, but not as complex as the automatic stay. And I'm going to switch over to Gary to kind of touch on his topics. I want to give him enough time to cover what he needs to cover. So go ahead, Gary.
Thank you. So I just wanted to throw one tidbit on the end of the claim discussion before I forget. It'll be relevant. Like Milos mentioned, always in a 13, if you should be filing a claim, file it. Not every court will have adverse effects in every situation, but you're opening yourself up to that risk. I'll point you, I just wrote an article about this. It's on our website and it went out by email, that there are some courts, I believe it was Northern District of Indiana, that had some fairly significant case law out there, that even on a direct pay in a Chapter 13, creditor does not file a proof of claim, you're out of luck if they fall behind. They will not let you file for relief. There's established law there that they're behind, you didn't file a claim, even though they were listed in the confirmed plan as direct pay, you need to wait 5 years. And so what happens in that situation is, doesn't help you. It also doesn't help the debtor, who, if they don't keep paying, they're gonna get out of the bankruptcy and get their car repossessed and whatever. So just keep that in mind always. My general principle, like Milos, is even on direct pay, file the claim, keep an eye on the bar date. There's certain provisions if you didn't get notice, and if there's other provisions in the code where sometimes the trustee or debtor's counsel can file a claim in a certain time period as well, but don't ever rely on that. Always protect your own interests yourself. So my first topic I would like to cover is trustee payments and how do you apply those. That generally can feel like it's an easy question, but as most things legally, it can depend. What I can tell you is, if you apply trustee payments incorrectly, a couple of things can happen. First, it can become very messy to unwind later. Bankruptcy payments can be difficult enough as it is. As I'm sure everybody knows, there's no perfect banking system that can cover application in a non-bankruptcy world and application and accounting for the terms in a bankruptcy plan, let alone if that case is dismissed. So if you don't apply correctly, you could run into a situation where you need to account to somebody. You need to account to the court, to debtor's counsel, to the debtor, to a Chapter 13 trustee. And what you don't want to have to do is have to unwind and spend significant effort on your side to reallocate money how it should have been. a debtor's attorney and a trustee is going to know if you're taking a long time after a question like that, they probably understand what's going on, and that can bring some unwanted attention on you. You don't want to have a situation in front of a court where you bring attention and make them start digging into your records. That's never a good place to be, because it'll bring doubt not only on that situation, but it's going to bring doubt about, okay, I saw creditor XYZ, and judges have good memories. And so if they see one time and they realize, I remember the situation where this creditor could not answer why they applied this payment here and this payment here, and what's actually due still pre-petition, and what's debtor due for post-petition. The next time you come in front of them, it could be a year later, 2 years later. It's that same judge. And by the way, the judges talk to each other in the districts. They're going to go, oh, look, it's creditor XYZ again, and we have a situation with payments. What's going on with them? Why can't they get it right? Or they might not even seem like there's a situation, but they might be skeptical. They might be looking at your motion and just not be sure. So how do you apply? In a Chapter 13, it depends what your account is for. I'll deal with vehicles first. There's multiple ways that a Chapter 13 plan can provide for your vehicle. You might have a situation where the debtor filed bankruptcy, and at the time they filed bankruptcy, they were behind. So you're going to have a pre-petition arrears bucket. That'll be reflected on your timely filed proof of claim. That amount, many times, will be paid by the trustee through disbursements after confirmation of the Chapter 13 plan. You may also have a situation where the debtor says, that's going to happen, the trustee is going to cure those pre-petition arrears over the life of the plan, but we're going to start making our payments directly. And we'll cover direct payments more in my next segment, but just be aware, you can have both of those situations happening at the same time. And I'll explain why that's important. You can also have the situation where the trustee is going to pay on those pre-petition arrears that are on your claim, but the trustee is also going to maintain contractual payments post-petition. That can be confusing because you might be getting multiple payments from the trustee and not knowing where do they go. I'll loop back in a second and explain an example and how you might be able to decipher that. The final situation you might see on vehicles is the debtor may say, and this is rare, but they may say, I'm going to not only be responsible for paying you directly on the payments that come due after I filed bankruptcy, but I'm going to cure those pre-petition arrears myself. So how do you apply when you're going to get some sort of trustee payment? How do you apply where that goes? If you're in the situation where the trustee is paying your pre-petition arrears only on your vehicle claim, and the debtor is paying directly post-petition, you need to make sure that your payment processing division or process understands where funds coming in the door are coming from. If you're getting a check from the Chapter 13 trustee, that's important information. You need to apply that in this situation only to those pre-petition arrears that are on your proof of claim, period. You don't apply those to, they filed bankruptcy today on 7/11 and they have a contractual payment due on 7/15. You don't apply that to that amount. You need to apply only to those oldest arrears that existed when they filed bankruptcy. If they are maintaining payments through the trustee, you'll sometimes hear referred to as conduit. You may get one stream of payments from the trustee. They may send you multiple checks per month. For example, in Western PA, many times the trustee will break you will file one proof of claim for that vehicle or that mortgage. And there's pre-petition arrears, and then there's the post-petition contractual payments. And in Western PA, the Chapter 13 trustee pays everything. There are no actual direct payments outside the plan by a debtor. So in that situation, you might get a check, your contractual payment might be $500 a month. And you're going to get that lag after the case is filed and then the plan's being funded. And then you might not get a payment for a few months. You finally get, all of a sudden you get a trustee check and it's $1,000. What's that $1,000? Usually they'll put a notation on it in Western PA of what that is for. Is that for pre-petition arrears, or is that a post-petition contractual payment? They might combine, and they might have one check for 1,000 and say, well, this amount is for this and this is for this. So the moral of that story is you really need to make sure when you're processing those funds and processing that check that you know who it's from and what the trustee is saying it goes to. If you don't apply that correctly, you're then going in a situation where, as I mentioned at the beginning, you're opening the door to everybody questioning your accounting practices, and you don't want to be there. If you try to file for relief later on, what we're going to ask for is a certain figure post-petition, and if you just say the arrears are X, and there's been a misapplication of funds, and we're not aware that's what's going on, we might walk blindly in a situation where we file, they're due for, X dates, and then all of a sudden the trustee files a response and the debtor files a response, and they say, well, no, they're only due for this because they made these payments and the trustee dispersed these funds, and then you're having to not only unwind, that's more than likely becoming more expensive for you both internally and with representation because it's now becoming contested, that you can just try to fix at the beginning. Unfortunately, and this is probably a whole topic by itself, like I said, the banking systems don't account for it. So a lot of the process is manual. You need to manually track one way or another, whether it's the normal non-bankruptcy world and payment application, and just in case that case dismisses, or you need to track bankruptcy payments manually on a spreadsheet, for example. So if you ever have questions that, feel free to reach out. That's a topic that I won't say it always gets creditors in trouble, but it's one of the slippery areas that can unknowingly and easily get you in a predicament you don't want to be in. Let me just check really quick, see if there's any questions on that. So I don't see any questions on that. If you have any, feel free to submit. So the other topic I was going to cover is, it goes a little bit hand in hand with the trustee payments, but direct payments. Do you accept direct payments? Generally, yes, you should, but as always, there's a few disclaimers and clarifications in there. As I mentioned when we were talking about the trustee payments, if there's a plan that provides that you're going to have your post-petition payments paid by the debtor directly outside the plan, yes, not only should you accept the payments, you are required to accept those payments. Don't turn a debtor away when they try to pay and say, no, we can't accept your payments, you filed bankruptcy. That's going to cause issues. They may have different ways they have to pay now, because parlaying it into the auto pay situation, they may have had auto pay set up for bankruptcy and they file bankruptcy, you turn off the auto pays. The debtor might call and might say, can I make a payment? Whatever options are in auto pay, you're still free to provide. Whether they can phone in a payment, they can mail in a payment, they can come in a branch and make a payment, those are fine. If they're making the payment out of their own volition, that's fine. You also run in a situation where auto pays are turned off and a debtor will act like they did not realize their loan was not being paid. So always be prepared for that. That's not your fault. The obligation is on them to make sure the payments are being made. The obligation on you is to make sure you accept those payments when they try to make them. So that would be, secured debt. So they could be paying the mortgage, they could be paying their car. The little grayer area when you especially get in a Chapter 13 is, like Milos mentioned earlier, they have an unsecured loan. And in a Chapter 13, you're going to file an unsecured claim. Maybe you're owed $2,000. You're going to be paid as an unsecured creditor. But what if that debtor comes to you and says, I didn't include your unsecured loan in my bankruptcy. I didn't want to include that in my bankruptcy. I want my payments to continue. Here's $200 for my unsecured loan. Or, they ask you to move money from their savings or checking to cover an unsecured loan. Again, if it's a voluntary payment, I don't have an issue with it, but just be aware that you may run into the situation where their attorney is not aware that they're doing this, and they may cause issues later and ask for the money back. Or you may have a trustee that catches wind of it and wants the money, because you will have received better treatment as an unsecured creditor than creditor X, who filed their unsecured proof of claim and was waiting for an unsecured disbursement from the trustee later on in the case. So keep that in mind. If they're making a voluntary payment, my view is it's okay for you to accept it. Just be aware that you may need to unwind that later on. And Milos, did you have something to add in that?
No, but we did actually, after you were looking for questions, we did have two really good questions come in. So I don't know if you want to take a look at.
I'll take a look, yes.
Yep.
So we have one here. How do you apply post-petition debtor payments if the trustee is paying pre-petition arrears? Many systems apply in arrears, and you cannot apply payments for the month currently in if debtor is delinquent. So unfortunately, and this isn't I'm sorry, this isn't a great easy answer. Spreadsheets. Because what we can't do, and it's unfortunate, is a court's not going to care if we say, well, judge, our system won't allow you to do, it won't allow you to do it this way. They're not going to care. They're going to say, part of a responsibility as a creditor is to abide by rules, laws, and regulations. And the bankruptcy code states X, Y, and Z. And so you need to follow the terms of the pre-petition plan that you agreed to. And that says that the trustee is going to pay this amount of pre-petition arrears. Your obligation is to apply those payments to those arrears. And the situation, and I was going to cover this then. This is the perfect time to cover it though. If you have a mortgage and you misapply the money, pre-petition, conduit payments, direct payments for post-petition, what's going to happen? Well, not only are you going to possibly have that problem if you try to file for relief or somebody asks for the status of the account. Fast forward to the end of the case, so your bookend. You're going to have what is called a notice of final cure on your mortgage that is filed by the trustee. From the time that's filed, you're going to have 21 days to file a response. And it's very important to understand, you have to file a response. It's not optional to file a response. Whether you agree with what the trustee is saying or not, you are required by the bankruptcy code to file a response within 21 days. If you have misapplied money, and so whichever way it is, trustee payments, debtor payments, the trustee is going to say, okay, the plan has been completed. I am disbursing no more money. The debtor's not paying us anymore. The debtor is now taking over their mortgage directly to you going forward. On that form, the trustee is going to say, you claimed pre-petition arrears of $3,000. And I disbursed towards pre-petition arrears, $3,000, and here's an accounting of all my disbursements. Then they're going to say, based on that, the debtor is next due for the July 15th payment of et cetera. When you respond, you have to both say, do I agree that all those pre-petition arrears were cured by the trustee? And what's the debtor due for post-petition? If you file a response that says, I don't agree with the trustee because he said he paid me $3,000 in pre-petition arrears and they're current with pre-petition arrears, but I'm showing they're due for $600, you then have to attach a payment history, a full payment history. And then that's going to be set for hearing. And you're going to have to explain, why is there a difference? Because you said you had $3,000 pre-petition arrears. The trustee records say they paid you $3,000. How are we getting to where they owe $600 more? And that's going to become costly. And it's, again, the whole situation where not only is there the legal cost, you're now having to more quickly rectify your records to make sure you get it right. So whenever you get those payments, that's why it's important to apply. Unfortunately, there can't be any excuses because nobody's going to listen to them. And that's one of the major consequences you can have later on if you have a mortgage, that you're going to run into more fees and more effort that you can try to avoid later on. So unfortunately, like I said, the summary is they don't care and you have to figure it out, how to make it work to make sure you follow it correctly.
The one thing I would add to that, Gary, is, some of the consequences if you don't file a response to that is there are some judges that will bring you in for a show cause, and they will make you prepare it and file it, and then you're gonna have to explain yourself why you didn't. On the flip side, also some judges, they may not bring you in, but if you don't respond, they essentially are gonna deem that the loan is current. So you can't later go and make the claim and say, well, the bankruptcy was done, we didn't get paid everything we were supposed to get paid. Well, you didn't file a response to the trustee's notice of final cure, and you're stuck. You can't make a claim for those funds because you never brought it to our attention. So.
And thanks for bringing that up, because that's actually a great point, and I've run into it. Not only will you have to, if you don't respond, you have to basically wipe that difference off your books. You cannot collect that. And if you do collect it, you're facing contempt and sanctions. I've had some situations in the past where some clients weren't receiving mail notice. By the way, just a blurb, that's why you want to sign up for electronic notice. Weren't receiving mail notice, didn't get timely service through the mail of the trustee's notice of final cure, never filed a response. Whether it was a legitimate issue or not, or a misapplication issue, they were showing a past due balance that would have been covered by the cure. They then go and they start sending statements to collect on it. They make calls. Well, debtor's attorneys open the case back up. They file a motion for contempt and sanctions. And so what ends up happening? Not only do you have to wipe that amount off the books that you were required to do by the code anyways, you now are paying their attorney's fees to bring the motion, and you're paying damages, which could be thousands of dollars. And you're paying us to defend the motion. So the dire consequences from not responding to it, in addition to show cause, where you might have to have one of your staff or managers go in person for a hearing and waste that effort. There can be extreme consequences for not following the procedures. Another question here is, having payment history spreadsheets okay in case of an audit or anything similar? I think I would need a little more clarification on that, but if what you mean is, if we're tracking those payments like we discussed outside of your system, because of bankruptcy on spreadsheets, to me, it's fine. Now, that might be something that you may want to run past your compliance department, your internal counsel, and I would ask that question of your auditor. Everybody's aware of the bankruptcy issue, so I think as long as you make sure you're keeping appropriate records and complete records on that spreadsheet, not just titling it spreadsheet X for John Smith, then I don't see an issue. Milos, do you see any issue with that?
No, not at all. I've seen clients do it every which way, right? The only thing I would add is, and we're kind of at the 10-minute mark. I don't want to take up too much of your time, Gary, but I've seen clients maintain separate spreadsheets on the side, right? I've seen clients where they just deem the account current. When the bankruptcy's filed, they put the arrearage into like a separate bucket. They almost open like a side account, right? Making it like a 0% interest, whatever it takes for you to properly track it in compliance with the confirmation order. I generally don't have an issue because we understand the limitations of people's software. The only thing I would keep in mind is, if the debtor's Chapter 13 ends up getting dismissed, which is, I think, fairly common. I don't know what the dismissal rate is now, but at one point in time, it was half of all Chapter 13s fail, right? You can revert back to the original terms of the loan and then reapply those payments as if they were being applied during the original terms of the loan. So you're no longer, if the case doesn't complete successfully, it ends up getting dismissed, those payments are applied just like you normally would. You're no longer bound by that plan because the plan is no longer in effect.
I just have there's two really good questions that are on point here. Just want to make sure we get these covered. One is, what if an unsecured debt is discharged and the debtor wants to make a payment after the discharge? Okay, so that I would put in the voluntary payment bucket. So they do not have any personal liability. Their personal liability has been discharged. So you can't show a balance. They may ask you, what's my balance? You can't give them a balance. They may ask, what's my payment amount? You can't give them a payment amount because there technically is none due. But if they decide their own volition, they call in and I want to make a payment on my signature loan and I want to pay $100. You can accept the payment. You're going to be tracking on your side to some extent what their loan balance was. So you can't keep accepting to infinity. Once they're paid off, they're paid off. But just remember, you can get in trouble if you cite a balance, send a statement, tell them there's an amount due owing. If they can access on your online systems, if they can see either those are discharge violations, which are even worse than stay violations. But you can accept them if they're actually completely voluntary after discharge. And the one other question I wanted to answer here is, it was specific to that example I was mentioning about Western PA, is what if Winnacor, who's our Chapter 13 trustee, isn't specifying what is post and what is pre on payments? So if that's the case, you have a couple options. If you have access to the trustee website, trustee ledger, there will be a breakdown in there, because I know on her website, she will break down what is being dispersed on pre-petition arrears and you can go and click on the checks and see the disbursements, and then she'll create her own claim for post-petition payments. So that's one way. Another way, we have access. If you have a question, we can always obtain a trustee ledger for you and explain that information. And then the final way, if you don't have access or you prefer not to come to us, I would contact the Chapter 13 trustee's office. I will say, and it could be because we're attorneys, but they are one of my favorite trustee offices. They're very, in my opinion, very friendly, very helpful, especially their staff. And so as long as you're the creditor and you're contacting, I think they're going to answer questions, and they might actually be able to help you and say, okay, this is what you can look for on your check or your check stub that lets you know what these are for and where you should apply them. And then, as always, any questions on that, feel free to ask us, and we can always access and ask questions on your behalf as well.
Okay. I wrote down we had a couple questions that we're kind of swirling through. I want to circle back in a few for the last couple minutes, and then I got some closing remarks. But co-debtor stay and credit reporting. So just real quick, I'm not going to do it any justice, so this could be a whole presentation on its own. There is co-debtor stay in a Chapter 13. There's not a co-debtor stay in a Chapter 7. So if you have a customer member, whatever you call them, debtor that files for bankruptcy, and it's a Chapter 7, and there's a non-filing party, everything remains normal as to the non-filing party. You can send billing statements, call, collection letters, everything. If it's a Chapter 13, you cannot do that against a non-filing party without relief from the automatic stay. And the second kind of shoot-off question was the co-debtor and credit reporting. Whether it's a 7 or a 13, the co-debtor is, if there's a non-filing party, that non-filing party is not in bankruptcy, so his credit reporting should not change. That's the short, easy, quick answer. If they're not in bankruptcy, the credit reporting doesn't change, regardless of whether a co-debtor files or not. If a debtor agrees to voluntary payments, does it need attorney's signature? Not really. I mean, I'm comfortable enough, if they just sign something like, hey, I know I filed bankruptcy, but I still want to pay on this loan. I know my payments are completely voluntary. I'm fine with that. I don't think an attorney needs to get involved. What if there's a guarantor on a debt, business debt, and the guarantor files Chapter 13? Yeah, you want to file a proof of claim. It's their debt too, as a guarantor. So you have potential to get paid there, depending on if it's secured or not secured, and who owns the collateral. There may be some, an objection to plan, or you may get paid as a secured creditor. You always want to file a claim if you're owed money. And the last one that kind of came up that I just kind of jotted down, I thought was pretty good. What happens if you sell the collateral at auction, but don't find out about bankruptcy until after? I'm assuming that's a question. If the debtor, you repossess the car, debtor files bankruptcy, you sell it, and then you find out about the bankruptcy after the fact. If you sold it before the bankruptcy was filed, you're in the clear. If you sold it after the bankruptcy was filed, you have a potential problem, whether you repossessed it before or after. But I've had that happen maybe one time, and I think the debtor ultimately just said it wasn't worth the hassle, but I think potentially you'd have to undo that transaction if you can. That would be the first step. But the second one is you maybe, even though it wasn't an intentional stay violation, a stay violation is a stay violation, where we said that, the debtor's attorney gives you a little bit of leeway, but if there ended up being damages as a result, I think you may be on the hook for the actual damages. I think if it was an honest mistake, you wouldn't be hit with any kind of punitive damages or even attorney fees, but the actual damages, I think you're on the hook for. So Gary, if you want to add something more, and then I'll make the closing comment.
I'll just add really quick on that, and I agree. You may, depending on the situation, if you repossessed it pre-petition and it was because they surrendered it, you're probably not going to run into an issue. Just, stay quiet. You probably won't run into an issue. But if you sold it and you repossessed it pre-petition and then they're wanting the car back, you're going to run into an issue. And at that point, I've seen multiple things happen, and it's not been frequent. It maybe a couple times, but there's been where you've had to pay out for damages and pay attorney fees, the whole same contempt sanctions idea. And then was one time where the resolution was actually having to do a substitution of collateral because they could not unwind because the vehicle was auctioned, gone, title changed, and so they agreed to the debtor to purchase another vehicle with proceeds, and then the creditor got a lien on that vehicle, and that vehicle is paid through the plan. So in short, just keep an eye on your accounting and your processes, and you won't run into the situation.
Okay. All right. Just closing remarks. Thank you for attending today's Weltman webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on various topics such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library in our follow-up email. Thank you again for attending. And one other thing I want to add, we do drive these presentations based on what you guys want. So if we see overwhelming questions in one way, or you give us feedback and say, you know what, we want to see, topic X, Y, or Z, if the response is overwhelming, we will set up another webinar. So we do listen to your comments. So thank you again for attending, and have a great rest of your day.